Hi, my name's Buddy Baker. I'm speaking to you from the comfort of my home in Chicago, Illinois. I'm sorry I can't participate in today's event in person, but I guess the next best thing to attending an IIBLP event in person is participating virtually, so I'll give that a try. Professor Byrne asked if I might be interested in making a short presentation on a topic that I would think would be of interest to the folks participating today. And I thought I'd do something on guarantees, and in particular, a short presentation on misunderstandings that people have about the authority of banks in the United States to issue guarantees. The fact is that even U.S. banks seem to misunderstand the regulations, and of course that doesn't help when they're trying to explain them to people around the world. In my career, I've worked for a number of banks, some of them large, some of them small, and even one U.S. office of a foreign bank. At present, I work for Fifth Third Bank. I'm in the Chicago office, but the headquarters is actually in Cincinnati, Ohio. And I'm in charge of a group that is responsible for keeping up with the rules and regulations so that that pertain to trade, so that we can help our customers structure transactions to their satisfaction. And like I say, I've been in this business for a long time, so I've worked for a few other banks. The situation is that I guess a lot of other bankers here have been in the field for a long time too, and they have long memories. The regulations changed about 20 years ago. But prior to 1996, there was a regulation here. It was not an actual prohibition, but a regulation that was used by the bank examiners determining whether banks were operating in a safe and sound manner. So they call this the safety and soundness regulation. That was pertained to letters of credit, said that letters of credit should be called letters of credit. I don't know what the point was. It's like I'll give you the story here, but it was since changed. In the mid-1980s, I was working for the First National Bank of Chicago. Some of you might remember the First National Bank of Chicago. It's now part of the J.P. Morgan Chase organization. And we, and actually Chase Manhattan at the same time, both had customers who were bidding on contracts that were being offered by the Saudi Arabian government for infrastructure projects. And in order to participate in these projects, they had to post what were called letters of guarantee for bid bonds and performance bonds in favor of the Saudi Arabian Monetary Authority. And reading these letters of guarantee, it was a very strict format that the SAMA required that people use, and if you didn't use it, you'd just be disqualified from the whole process. So people really wanted to use it word for word, and it was fairly evident when you read it that what it really boiled down to was an undertaking, an independent undertaking to effect payment to the beneficiary. So it's an undertaking by the issuer, presumably a bank, to pay against presentation of documents. It had a specified amount, specified expiration date. There were really no problems with it, and it was very obvious that under Article 5 of the Uniform Commercial Code in the United States, at least, these were letters of credit, just calling themselves something different. So we and Chase went to the authorities, the regulators, and they gave both of us permission to do these. So that was sort of limited permission. At about that time, there were a number of other projects that were just getting off the ground over here. Internationally, there was the revision of the UCP was going on. But in the United States, there was some talk about whether we needed a new set of rules for standby letters of credit. So there was talk was just starting about developing the ISP. And then we were in the process of revising Article 5 of the Uniform Commercial Code. And so there was a lot of attention being paid to rules and regulations, laws, etc. And the regulators were participating, at least in the Article 5 revision process. And the discussion came up again. You were going through the definition of letter of credit in the law. And it was became very well understood by the regulators that there really was no reason in the safety and soundness regulation to continue this requirement. It took a few years, but in 1996, the regulation was revised, and instead of being authority of banks to issue letters of credit, it became authority of banks to issue independent undertakings, and they removed the requirement that they be called letters of credit. So now that's been 20 years that banks in the United States have actually been authorized to issue what many people would refer to maybe as demand guarantees. At least have been authorized to issue letters of credit and call them demand guarantees. And it's been my position for some time that under the ISP, I can issue stuff called demand guarantees and make them subject to the ISP. And for that matter, the new uniform rules for demand guarantees seem to be, pretty acceptable, very, similar to the ISP, or obviously based on the UCP. And therefore, there's really no reason that I can't issue letters of credit if I want to, call them letters of credit and say they're subject to the uniform rules for demand guarantees. That works well also. The only real restriction is just that banks need to make sure their staff is trained on whatever set of rules it is that people might want to use. At this point, at Fifth Third, we have trained our staff so that they are aware of the differences between all three of those sets of rules. As a matter of fact, we've even done training on what would happen if you issued a letter of credit that was not subject to the ISP, the UCP, or the URDG, if it were just subject to the Uniform Commercial Code. And we've discussed, although we haven't really implemented this, issuing letters of credit subject to the UN Convention on Independent Guarantees and Standby Letters of Credit. Seems to me to also provide a very satisfactory framework. So anyway, I say that's really the limitation at this point, is having staff who are trained, ready to use these other rules. Something else that did happen that people are not aware of in 2008, no one seems to be quite aware of why, who asked the regulators to do this, but there's another regulation in the same area. It's a matter of what banks are authorized to do as opposed to a prohibition. But in the banking regulations, it has said until 2008, it said banks could not issue guarantees. Effectively, banks could not guarantee the obligations of their customers unless they had a financial interest of their own in the transaction that they were guaranteeing. We use that exception to do steamship guarantees, or what maybe people call letters of indemnity for missing bills of lading. And so we've done that for a long time as well as an exception. But then in 2008, they actually revised that regulation as well. And banks in the U.S. are now authorized to do accessory guarantees. We are allowed now to actually guarantee the obligations of a customer. The one restriction there, if you will, or limitation, is that the bank's undertaking has to be financial. So even though the customer might have a performance obligation, the bank cannot undertake to perform the customer's obligation. The bank can only undertake to make a payment because of the customer's failure to fulfill their end of a contract. I don't know. Like I said, we're not sure who asked for that. I don't know any banks who really intend to do accessory guarantees in the United States. We're really pretty happy with doing demand guarantees or standby letters of credit. But one thing that maybe that has cleared the way for has been, and this I think is very useful at this particular point in time, is the authority of banks to avalize trade acceptances. The law in the United States, now this is in Article 3 of the Uniform Commercial Code. That's where we discuss negotiable instruments. But the law here has long discussed the obligations of a party who adds an endorsement to a trade acceptance as an accommodation. That's the language over here, but it's the same meaning as adding an aval. If you read like the Geneva Convention, for example, the discussion is the same as an aval in the Geneva Convention. Banks have hesitated, thinking that, gee, that's adding a guarantee to a customer obligation. We have done bankers' acceptances, obviously, so we have no trouble with that being our own obligation. And we have even, well, certified checks are really bankers' acceptances because they're drawn on banks. But some banks actually most banks have hesitated, I think, to avalize drafts because of that regulation. And like I say, even that's now been changed. I personally think that that's very timely because I foresee a re-emergence, if you will, of trade acceptances in the marketplace, based largely on the dwindling use of letters of credit. I think what we have now is importers, buyers, who are looking for longer and longer terms, or looking for working capital from their suppliers, more so than from their banks. And they don't want to use letters of credit. So what we have now is a situation where suppliers are looking for other ways to get financing, other ways to mitigate risk. And I think 80 or 100 years ago, trade acceptances were a very popular way of doing both of those things, and in particular, a very common way of financing trade. At least that's my understanding. Like I say, with the migration away from letters of credit and the increased desire of importers to get longer payment terms from their suppliers, I think trade acceptances have maybe not yet have they done it, but maybe they'll come back in vogue. In order to mitigate risk, it's very useful for banks to add their aval or accommodation endorsement. And so I see that that is one, although this regulation was changed in 2008, that's hopefully one outcome of that change that will facilitate or encourage the use again of trade acceptances. Anyway, hopefully that was useful and informative. And again, sorry I couldn't be with you this time, but maybe next time, or I invite you to come to one of the IIBLP events here in the U.S. I am typically able to attend those. So until then, thanks.